Hello, good evening, and welcome to Unacademy. In this session, we will discuss 10 important news articles from Indian polity which appeared in various newspapers such as the Hindu, the Hindustan Times, the Indian Express in October 2025, relevant for both prelims as well as the mains examination. If this initiative of ours, where we cover current affairs month wise, subject wise, is aiding and helping your preparation, do let me know in the comment section. And do not forget to like this video and subscribe to our channel if you haven't yet. Before we start, an important update: understanding current affairs becomes even more easier if you have conceptual clarity, if your foundation is strong, and if you wish to enroll in our foundation course for CSE 2027 or beyond, now is the right time because our courses are now available at 25% discount. And this I'm sharing it with you because for the first time ever, even our platinum course, the fee is reduced by 25%. Go to our website, check various options, use this code, and you will get the lowest possible subscription fee to prepare for this exam. Let's get started and let's look at topic number one: a vague, unlawful zone, which appeared in the Indian Express. Now, how do I make you understand this topic? You may have listened to a Hindi movie song, Chahe tum kuch na kaho, maine sun liya. So, the camaraderie relationship between two individuals, even if you say nothing, the other person understands it. Unsaid words. Or if you are following Hollywood movies and you would have watched Ocean series, Oceans 11, Oceans 12, Oceans 13, look at the camaraderie between George Clooney and Brad Pitt. Even if George Clooney does not utter a word, Brad Pitt understands. Unsaid words. While preparing for the civil services exam, when you read a particular book, the educators tell you don't just read in between the lines. And that's something Allahabad High Court has done. And to understand that, we need to understand what is Section 352 of the Bharatiya Nyaya Sanhita, which has replaced, you would know, Indian Penal Code. Now, imagine it this way: I'm an individual and I'm intentionally insulting in any manner. Who am I insulting? Maybe the police. Because of that insult, what happens? I provoke other people. For example, I provoke you. And because I'm insulting somebody, maybe a police force, through which I'm provoking you, and I'm provoking you to such an extent that I know that you will break the law, that you will hinder public peace, that you will commit any other offense, it is a crime under Section 352 of the Bharatiya Nyaya Sanhita. So, what is a crime? If I intentionally provoke you by insulting somebody, and thereby I know if I'm provoking you, you will commit breach of peace, you will commit a violent act, you will commit any other offense, you will hinder public peace. Now, what has happened in this case? There is an individual belonging to the Muslim community who was in a relationship with a Hindu woman. Ultimately, the family convinced this individual, don't marry this person of another faith because there will be controversy. Long story short, this individual was arrested. And then his brother posted something on his WhatsApp, communicated to few people and posted something on WhatsApp. And what did he post? He said that we have been framed in a false case and political pressure has been imposed on the police. So, police is acting under political pressure. There is a concerted campaign launched against us where people have decided to totally boycott our family business as well, our shop as well, which will affect our livelihood. But in the same sequence, this person is saying that I have full faith in judiciary, that judiciary will unearth this controversy, this conspiracy, and the judiciary will expose this lie. This individual was also arrested. The brother of the original individual, he was also arrested because he posted something on WhatsApp. Matter went to the court, and now court had to decide, the Allahabad High Court had to decide whether this person should be put on trial or not, whether he should face the trial or not. And the case was under Section 352. The court was told that this person has intentionally insulted the police force, provoking the members of the Muslim community because they will feel that they have been targeted because of their faith. And because of that, you're provoking Muslim community so that they can violate the law, so that they can commit any offense, so that they can commit the breach of peace. Allahabad High Court said, even if you have not said anything, even if we read in between the lines, your intention is to provoke your community into taking law into your own hands. So you will face trial under section 352 of the Bharatiya Nyay Sanhita. Now, the question before the court was, can a person be charged for trying to create discord between religious communities with unsaid words? Because he did not use the word Hindu or Muslim in his WhatsApp communication. He did not directly instigate people to commit riots. But the court had to decide whether unsaid words, even something which you have not spoken, something you have not mentioned, something you have not written, can be assumed to be violation of the law under section 352. And what Allahabad High Court said is that through his statements, through his WhatsApp communication, this individual is trying to stoke interfaith strife even without explicitly mentioning any religion. So चाहे तुम कुछ ना कहो, मैंने सुन लिया. Something which you do not say explicitly, but the other person understands. Even that subtle message can lead you into trouble and you will have to face the law. That's what Allahabad High Court has said. Because the reasoning of the Allahabad High Court was that members of a particular community, in this instance, the Muslim community, could think that they are being targeted by the members of another religious community, for example, Hindus. And Hindus and the police, they come together, they violate the law, they are colluding with each other to target the Muslim community. So you are trying to stoke inter-religious strife, which is a breach of law, and for that you will have to face the trial. For that, Indian Express wrote an editorial and critiqued the Allahabad High Court's decision. Indian Express asked and said that these criminal laws, especially if it deals with fundamental rights, they need to have explicit or definite meaning. Because if the law is vague, it is liable to be used, overused, misused, abused. And that vagueness has been described by the Supreme Court in the landmark Shriya Singhal v. Union of India 2015, that a criminal law cannot be vague. And if it is vague, it is liable to be struck down for violating fundamental rights. What was that Shriya Singhal case? Information Technology Act was passed in the year 2000, and then this law was amended in 2008. And in 2008 amendment, section 66 capital A was inserted into the Information Technology Act. Under this section, the provision said if you are using any electronic device, whether a smartphone or a laptop or a desktop, through which you are transmitting messages, and these messages cause annoyance, then you are a criminal. You will have to face the music of the law. This was section 66 capital A. And this section was used when a lady in Maharashtra, she posted on her Facebook profile, said, what is the need to organize a bandh if Bal Thackeray, the supremo of Shiv Sena, is dead? So Balasaheb Thackeray died. Shiv Sena members enforced a bandh in Maharashtra. She critiqued it, criticized it. What is the need to hold the entire state into ransom when a political personality had died? But she was using a computer device to transmit a message which caused annoyance to the members of the Shiv Sena. So this lady, Shaheen Darda, was arrested under section 66 capital A. In fact, her friend liked the status. She was also arrested because through her explicit communication, you are causing annoyance to the members of the public. As such, it is a crime. Similar cases of abuse took place. And ultimately, a law student, Shreya Singhal, approached the Supreme Court, and a two-judge bench of the Supreme Court in 2015 said this Section 66 capital A is unconstitutional. Why? Because it not only violates freedom of speech and expression under Article 19(1)(a) of the Constitution, but this law is vague. And a criminal law cannot be vague. If it is vague, it is liable to be struck down because a criminal law has to be definite in its understanding. People should know, ordinary people should be able to know and understand what conduct is prohibited and what conduct is permitted. If you don't know, then you are in the gray zone of a law and you can be abused and penalized. And Indian Express is arguing that this section 352 of the Bharatiya Nyaya Sanhita is also vague because through this section, even unsaid words can be deemed to be committing a crime, and as such, you will be prosecuted. This amounts to what critics argue violation of the overbreadth doctrine. And what is this overbreadth doctrine? This is the example that I often cite while discussing this topic, and I will give the same example again at the expense of repeating myself. Some of you may have listened to this explanation before, but I'll repeat it for those who haven't attended my classes before. For example, Unacademy is the parliament, and I am a citizen of this country, clear citizen of this institution. And an academy has to pass a law so that my dignity is safeguarded, so that my dignity is protected. Because I see that there may be students who will try to transmit some messages which will affect my dignity and, as such, affect my mental progress. An academy decided to bring in a law: whoever, through messages, violates the dignity of the teacher, we will cancel your subscription. That's the law. But whoever violates the dignity of an individual. Now, this phrase, violating the dignity of an individual, can be very vague and can be misused and interpreted in different ways. For example, you are transmitting a message or posting a message in the YouTube chats as well, saying Sarmad sir will not evaluate the answers unless and until we pay him 1000 rupee for evaluation. Now, this is untrue. But if you are saying this, it is affecting my mental peace, affecting my dignity. As such, an academy will cancel your subscription. Legal, genuine. But what if you say that Sarmad sir had to take a class at 7 p.m. and he delayed the class, he started the class at 7:30, wasting our time. And then he is teaching irrelevant stuff which is not related to this exam, hence wasting our time. And he was supposed to take a 3 hour class, but he ended the class in 1.5 hours. And in 1.5 hours, he was discussing all sorts of permutations and combinations. He was giving us gyan, not giving us the content. You have a right to say this because I am wasting your time. But if you say this, that sir is wasting our time, he is not teaching to the point, he is not teaching as per the requirements of this exam, an academy may feel that you are violating my dignity and your subscription will be cancelled. If a law is like this, that the wording is such, listen to me carefully, that the wording is such that it will prohibit permitted things as well. For example, your criticism is genuine, we have to permit it. And it is also prohibiting non permitted things. In a sense, those who, which should not be allowed. For example, you saying or alleging that I take 1000 rupees to evaluate an answer. When a law is framed, drafted in this legal language, where it makes your constitutionally protected free speech a criminal offense, this law can be declared null and void on the basis of this doctrine known as overbreadth doctrine. And Indian Express argues that this section 352 falls foul of this overbreadth doctrine, and as such, it should not exist. Or its interpretation should be done in such a manner that it is not misused. Critics argue that this section 352 of BNS amounts to something known as thought crime. Have you heard of thought crime? If you have read this beautiful dystopian novel written by George Orwell, 1984, where Big Brother is watching you, it is about the surveillance state, where every action of the individuals in Oceania is being watched by the big brother. Big brother is watching you. In those areas, even thought crime is a crime. Even if you're thinking about a crime, you will be prosecuted, you will be arrested. And there were thousands of people who were made to disappear in Oceania in that dystopian novel, 1984. In one instance, this is important. There was an individual, the protagonist is Mr. Winston in 1984. His neighbor, Mr. Parsons, was arrested. You know why? Because in his sleep, subconscious mind, he spoke against the party in power of Big Brother. And this individual, Mr. Parsons' daughter, complained to the police that in his sleep he is going against the party. That is a crime. So, when for unsaid words which you have not spoken, which you have not written, if you will be prosecuted for that, it amounts to that surveillance state, a totalitarian regime where there is no freedom of speech and expression, where the state controls even your thoughts. That's something that you need to understand from this topic number one. Let's look at topic number two. Can a third party be liable for marital disruption? Now, what is this issue? Remember this case, Shaili Mahajan v. MS Banushri Bail, 2025. This is the order of the Delhi High Court. The Delhi High Court and this order of the Delhi High Court raises questions on whether Indian civil courts can impose liability for third party interference in marriage. How? This is something which can be relevant for your sociology as an optional, for anthropology as an optional, but listen to me carefully. There was section 497 of the Indian Penal Code, which dealt with adultery. And adultery was a crime. Now, what is adultery? For example, this is a husband and this is a wife. They are in a relationship with each other, they are in a marital relationship with each other. Now comes the outsider. Let's say this outsider is a male, and this outsider indulges in sexual relationship with the woman, with the wife of another individual. This amounts to adultery. And who will be prosecuted for that? This male. It's a crime. Crime is against the state. That means you will have to serve time in the jail. But what about this woman? Because it was a consensual relationship. The wife of this husband agreed to it. No action will be taken against the woman. Why? Because it was thought that woman is always a victim, man is always a seducer. That was the logic why, in this adulterous relationship, only the outsider male will be prosecuted, not the woman. Why? Because woman is always a victim, man is always a seducer. But look at it this way. What if this wife engages in a relationship with a man outside the marriage, but this time with the consent of the husband? Husband agrees to this, then it is not a crime. Why? Because the thought process was wife is the property of the husband, and if the husband wants to share this property with another man with his consent, then it is not a crime. If the consent of the husband is not taken, then it amounts to classic case of theft. Because if you are the property of the husband and someone is trying to snatch this property, this is a case of theft, which means adultery, which means this outsider male will be prosecuted. In a landmark judgment in 2018, in Joseph Shine v. Union of India, 5 judges of the Supreme Court said this section 497 is unconstitutional. What Supreme Court said? Adultery is absolutely a matter of privacy. And this is where the state cannot get involved because crime is against the state. Even if it's an adulterous relationship, it is still privacy at its pinnacle. What we can do is we will not make it a crime, we will not continue it as a crime. At maximum, it can be a ground for divorce, which means this husband may grant divorce to his wife if this wife is in an adulterous relationship with an outsider man. At max, it can be a civil wrong, it can be a ground for divorce, but it is not a crime. Supreme Court said something else. Supreme Court said, and this is where the Supreme Court spoke about autonomy. Supreme Court spoke about constitutional morality. Supreme Court said, does this wife lose her agency, lose her autonomy to explore sexual relationship even outside the marriage? No, this is her privacy. This is her autonomy. This is her choice. This is liberty as guaranteed in the preamble of the Constitution. And that's the morality that we will have to impose in this country. So, your morality, my morality, religious morality, caste morality does not enter into the picture at the expense of constitutional morality, which is based on liberty, dignity of an individual. So, does she lose her autonomy over her sexual freedom just because she has entered into a marriage? No. Maximum, it can be a ground for divorce. Now, listen to me carefully. If it is a ground for divorce, can it also be then not a crime? Can be a ground for divorce? Adultery judgment, Joseph Shine judgment, listen to me carefully, said adultery is not a crime. Maximum, it can be a ground for divorce. But in this case, can this husband, for example, if he is in a relationship with a woman and then there is a wife who is affected by this relationship, can this wife file a case against this outsider woman and seek damages? This is something unheard of, but the Delhi High Court has said yes. Delhi High Court said Joseph Shine only decriminalized adultery, but it did not foreclose any option of this outsider being sued for damages by the spouse. And this is what we call alienation of affection. What is this alienation of affection? This can be important for your exam. Alienation of affection is a term which is in United States referred to as heart-balm tort, a civil wrong, for example. What is the civil wrong? If the husband and wife are in a relationship, now there is an outsider woman who is trying to interfere in this relationship, and then this husband enters into a relationship with this outsider woman, then what will happen to the wife? She is being alienated in this relationship. She can seek damages from this outsider woman. Has this been spoken about in Indian law, in Indian context? The law says marriages carry legal interests like consortium, intimacy, support, a shared life. And if an outsider is trying to disturb this relationship, then it is a civil wrong. You can file damages. In Indian context, we have not in our laws codified or prohibited alienation of affection. So this is not provided in any law, but it is not prohibited in any law as well. What Supreme Court said in Pinakin Mahitpare Rawal versus State of Gujarat 2013, Supreme Court held that alienation of affection by a stranger, if it is proven, then it is an intentional tort, which means civil wrong, and you can seek damages. But it's not only about the wife, it's not only about the husband in a relationship who can seek damages from an outsider. Even the children can. This is what the Supreme Court said in Indra Sarma v. VKV Sarma. Supreme Court said alienation of affection could even give children a cause of action against a third party. Why? Because their father has been alienated. However, this doctrine has never been used in India, and perhaps for the first time will be used basis the judgment of the basis the order of the Delhi High Court, in this case known as Shelly Mahajan v. MS Banushri Bail 2025. In United States, for example, there are many states which allow this kind of civil claim, this kind of tort known as alienation of affection. But for that, three things must be proven. One, existence of genuine love and affection in the marriage. So there was genuine love and affection in the marriage. Now comes an outsider, and because of that outsider, this affection has been lost. And this affection has been lost because of the malicious conduct of this outsider. Deliberately, this outsider, knowing that this person is married, is deliberately, through malicious intent, trying to lead to the loss of this alienation. If these three things are proven, you can seek damages from this outsider. The Delhi High Court's ruling marks a significant step in recognizing civil recourse for spouses affected by interference in marriages. So, this can be important for your GS2, for sociology, for anthropology as well. That's topic number two. Okay, done. Let's look at another article written by Ms. Namita Bandare. She writes in the Hindustan Times: rape and victim blaming cues from leaders and judges. Again, in West Bengal, unfortunately, a medical student in Durgapur was raped outside her campus. The chief minister, Ms. Mamta Banerjee, says, although we are not defending the accused, but girls should not leave campus at night. Girls should not leave campus at night because the space outside the campus is not safe for them. And this is something that a woman chief minister of a state is saying. But she's not saying this for the first time. She said this in 2012 as well, when a rape victim, she was, the chief minister said when she complained that I have been raped by five men outside a pub in a moving car. She said that all these accusations have been fabricated, and you are fabricating rape because you want to demean my government. You want to convey to the people that my government is ineffective. At that time, the victim, her name was Suzette Jordan. Now, this is where it becomes interesting and relevant for your exam. Sir, in our law, we can't name the rape victim because you can't do anything which will reveal the identity of a rape victim. If you reveal the identity of a rape victim, that is a crime. It was a crime in Indian Penal Code. It is a crime in the Bharatiya Nyaya Sanhita as well under section 72. Disclosure of the identity of the victim of certain offenses. In this case, how is Miss Jordan, who unfortunately died at the age of 40 few years ago, how do we mention her with her name? This is where there are exceptions. Exceptions in the sense, yes, you cannot reveal the identity of the rape victim. Yes, you cannot reveal anything which may lead to people get to know the identity of a victim, which means you can't reveal her face, you can't reveal her name, you can't reveal even her father or mother, because then through father or mother or siblings you can identify the victim. It is a crime. But if you waive it off, if the victim in writing says, no, you can reveal my identity, then it is not a crime. And that's what Miss Suzette Jordan did in 2012. She waived off her anonymity and revealed to the public that I was the rape victim. So, in the writing, if the rape victim gives in writing, this limitation does not exist. Then you can reveal the identity, you can mention it. Or the victim is dead or is a minor or is someone with mental illness, then the next of the kin, maybe the guardian, maybe the family members, they have to give it in writing that yes, you can reveal the identity of this rape victim. Or if the person who is investigating this case, this person has to mention her name in the case files, in the diaries, in the FIR. In that case, you can mention, reveal the identity, but only if you're a police officer who is investigating this case and you need to reveal the identity as part of the investigation. Otherwise, you can't reveal. Disclosure of the identity of the victim of certain offenses, such as rape, is a crime under Section 72 of the Bharatiya Nyaya Sanhita. But be that as it may, the point is another woman chief minister, Sheila Dikshit, she was the chief minister of Delhi and a journalist. Soumya Vishwanathan was killed while driving home after a night shift. And what Chief Minister said? Why do you have to be so adventurous to venture out of your home at night if you are a woman? In a sense, giving a free pass to men to torture, victimize, and assault women who happen to do something adventurous by venturing out at night and doing their job. Goa Chief Minister Pramod Sawant in 2021 said there are two girls, two minor girls who have been raped, and it is the fault of the parents. Why did you allow your two minor girls to venture out at night? Because you allowed, that's why they got raped. His Excellency RSS Chief Mr. Mohan Bhagwat, he says rapes are happening in India, not in Bharat. In a sense, rape is happening in the cities, not in the rural areas. Rape is happening in those areas which have adapted to or which have incorporated the Western values and not those who follow the Indian values. Former Uttar Pradesh Chief Minister Mulayam Singh Yadav said, in a sense, boys will be boys. They will commit quote unquote mistakes. And for these mistakes, should they be hanged? Boys will rape. That's what Mulayam Singh Yadav said. A BJP MLA from Bid, Maharashtra, Gopijan Padalkar, he advised women, you should do yoga at home. Don't go out to gym because you don't know who the trainer is and the trainer will assault. All these things tell us that our political leaders tell women that you should not venture out at night outside the campus because outside the campus you're not safe. You should stay at home because at home you are safe, outside you're not safe, and you can't venture out at night. So you should be in the college campus. Then what will explain when an engineering student of a private engineering college in Bengaluru was raped by her senior inside the college? Then should we tell these girls, don't go to college, lock up yourself at your home, inside the four walls of your home? And by the way, even the home cannot be safe. Because according to National Family Health Survey, one out of three women they face and they are subjected to sexual violence by a family member. Then should we banish women from families as well? All these things. Then we say she was asking for it because she went out at night. That's why she invited rape. She was wearing short dress. That's why she was raped. So we tend to shift the blame on the night, on whether the parents are allowing you to go at night, or you're being too adventurous, or because you're wearing something. If somebody is snatching your chain, do we accuse you or blame you? Why were you wearing a chain? And that's why it was snatched. We don't do that. So, for everything else, every other crime, we don't try and rationalize things. But for rape, we try to put the blame back on the woman. It's like you were asking for it. The answer to all these questions, Ms. Namita Bandare writes, it doesn't matter whether you were drinking. It doesn't matter what you were wearing. It doesn't matter at all because when we ask these things, we are reinforcing a message that woman belongs inside her house. Worse, we are giving excuses to men for rape because rapes happen because the simple explanation is that men rape. It's that simple. But instead, what we need to focus on, create safe environment for women. Law and order is the job of the state government. If outside the campus you are raped, which means there is a law and order problem, there is a policing problem, there is a dearth of CCTV cameras, there is dearth of policing, which should be the job of the state government. And when politicians say because you were raped, because you were in a previous relationship with this person, or because you were wearing something or not wearing anything, instead of focusing on these issues, our politicians should address why in our school curriculum we do not teach consent. That is why in our previous sessions as well, we have discussed that if there is a beautiful campaign called Beti Bachao, Beti Padao, there is also need for another campaign, Beti Bachao, Beti Padao, Beta Sikhao. So we need to teach men teach young boys at an early age what is consent. And this consent has to be unequivocal. And this consent can be revocable as well. You can't give consent forever. It can be revoked at any point in time as well. And that needs to be taught in the school curriculum. That's when this crisis will come to an end. Clear? Any questions as of now? Great. Let's look at another important article from the Hindu newspaper. What is the Supreme Court order on local polls in Maharashtra? Look at the image on your screen. Mr. Zohran Mamdani is now the New York mayor of a United States city, the youngest in more than a century, the first person of South Asian origin, the first Muslim to be the New York mayor. And when the whole world is debating, praising, or criticizing Zohran Mamdani for becoming the mayor of a New York city, what about Indian cities? You may not know who your mayor is. If at all there is a mayor in your city, Bengaluru has been without a mayor for the last 5 years. Bombay has been without a mayor for the last 3 years. We have urban local bodies, and these urban local bodies have been given constitutional status by the 74th Constitutional Amendment Act 1992. We have 12th schedule of the Indian Constitution, which allocates roles, responsibilities, functions of these urban local bodies. Yet, majority of these urban local bodies, with the exception of urban local bodies in Kerala, majority of these urban local bodies are defunct, useless, ineffective. Why? Because creating these urban local bodies is the job of the state legislature. Empowering these local bodies is the job of the state legislature. And constitution is conveniently used the term may. The state legislature may devolve these functions under 12th schedule of the Indian Constitution to urban local bodies. May also means may not. That is why critics have long argued that this term may should be replaced with shall. The state legislature shall devolve these 18 functions which are mentioned in the 12th schedule of the Constitution to these urban local bodies. But be that as it may, the point is, in these urban local bodies, there is reservation. Reservation for women. What is the quantum of reservation? Not less than one third. There is reservation for SCs. There is reservation for STs as well, in proportion to their population. But whether there can be reservation for OBCs or not, that is the job of the state legislature to decide. That is where the state legislature may decide to empower reservation, to empower some communities by granting them reservation in urban local bodies. But if you randomly select one community, randomly select one group and give them reservation in urban local bodies, that may amount to an arbitrary decision. And right against arbitrariness is your fundamental right under Article 14. So the decision in granting reservation, political reservation to some communities in urban local bodies cannot be an arbitrary decision. And to ensure that such a decision is not arbitrary, the Supreme Court gave an important judgment in 2021 in a case known as Vikas Kishan Rao Gavali v. State of Maharashtra. Supreme Court said you can provide OBC reservation in urban local bodies, but for that you have to perform what is now known as a triple test. Perform this triple test, and then you can grant reservation to OBCs in urban local bodies. What is this triple test? Number one, set up a commission, because it cannot be an arbitrary decision of the government to grant reservation to one group in urban local bodies. Set up a commission. And what will this commission do? Commission will study, commission will inquire, and see whether these groups which are under OBCs, whether they have representation in urban local bodies or not. If they don't have representation, that means we should empower them with reservation so that their political marginalization is taken care of. Long story short, the first thing that the state has to do is set up a commission. Commission has to conduct a rigorous empirical study. We'll have to study what is the nature of backwardness, and then what is the implication of backwardness as well. If we give them reservation, will this reservation empower them politically? If yes, then you have to specify, this commission will have to specify what is the quantum of that reservation, what is the percentage of that reservation, how many seats should be reserved for this particular group. And at the same time, test number 3, reservation should not exceed 50%, which means if you are providing reservation to SCs, STs, and now you're providing reservation to OBCs as well, put together, it should not exceed 50% of the total seats. Long story short, whether it is UP, whether it is Maharashtra, whether it is Gujarat, whether it is Assam, anywhere, wherever you want to provide reservation to OBCs in urban local bodies, for that you have to satisfy these 3 tests recommended by the Supreme Court in Vikas Kishan Rao Gavali v. State of Maharashtra. This triple test you have to take care of, you have to understand, that's relevant for your exam. But something else. When in Mumbai for the last 3 years, we do not have a mayor. There is one section of the society which says Mumbai still breathes, Mumbai still lives, the governance is still okay. Then maybe we don't have a need to get councillors elected to urban local bodies to run Mumbai. They say it is being run by bureaucrats. In any case, it will be run by the bureaucrats, because the design of 73rd, 74th Amendment is such that there are elected representatives who can only recommend works to the executive. And then these chief executive officers or commissioners who are appointed by the state government, they will have to implement the decisions taken by the political class, taken by the elected representatives of the people. So, in any case, if the decisions are to be implemented on ground by these bureaucrats, then what is the need to have elections to urban local bodies? We need to understand that we are a democracy. And in a democracy, bureaucracy is not designed to make decisions. Bureaucracy is meant to execute the decisions. Right now, political accountability of bureaucracy is missing. We need these bureaucrats to be made accountable to the elected individuals. And through elected representatives, you are accountable to the people then. If there are no elections to councillors, if there are no elections to the municipal corporations, it basically means the political accountability of bureaucrats is missing. And look at it this way. Recently, Maharashtra Chief Minister Mr. Devendra Fadnavis, he said that all these 29 municipal corporations that we have in Maharashtra should be headed by IAS officers, not the State Public Service Commission officers, IAS officers. Why? Because you're preparing for this exam and you know only the talented individuals crack this examination, which means you have something in you so that you are able to qualify this examination, which is considered to be the world's toughest examination. But the point is, if the chief minister is saying that all these 29 municipal corporations should be headed by IAS officers who are less susceptible to political interference, less susceptible to corruption. I'm not saying they're not corrupt, but less corrupt than the state level officers, which means the chief minister of Maharashtra is accepting, albeit discreetly, that running urban local bodies is difficult. And for that, you need elected representatives and you need senior officers to implement the decisions taken by the political class. And that's why we need to empower urban local bodies. Clear? That's about topic number 4. Any questions? Please let me know. Okay. Why don't I take the session for every month? I've taken this session for September. Now this I've taken this session for August, for September. Now it is for October, and after that it will be for November too. So we've taken this session every month since August. Now let's look at another very important article written by Sohrit Parthasarthi in the Hindu newspaper, calling out the criticism of the Indian judiciary. We need a scapegoat. I'm unable to crack this exam because I'm not lucky. We need a scapegoat. We are not developing well because we are a democracy, unlike China. So democracy becomes the scapegoat. And now it seems, according to the author of this article, judiciary is becoming another scapegoat. He cites the arguments given by Mr. Sanjeev Sanyal, who is a member of Prime Minister's Economic Advisory Council. He says, we will become a developed nation. We will become a Viksit Bharat by 2027, by 2047. But the biggest stumbling block in achieving that goal of becoming a Viksit Bharat is the judiciary. So he points out that the biggest impediment that we have, roadblock that we have to become a developed nation, a Viksit Bharat by 2047 is the judiciary. Why? He says, look at section 12 capital A of the Commercial Courts Act, which makes pre-suit mediation mandatory. You have to file a case in the court of law and the court will give the verdict. Better is if we use alternative dispute resolution mechanisms, ADR. Instead of directly going to the court, we may explore alternatives. And the alternative is mediation. This is mentioned where section 12 capital A of the Commercial Courts Act. Mr. Sanjeev Sanyal says, in majority of these cases in Mumbai, this pre-suit mediation fails, which means when it fails, we have to go to the courts. So Sanjeev Sanyal is blaming the courts. Why are you insisting on pre-suit mediation when it is bound to fail? But Mr. Sanyal, please understand, the courts here are to implement the law. The courts don't make the law, don't enact the law. If you have to blame the parliament which enacted this law and made it mandatory under section 12 capital A to have a pre-suit mediation before you can file a case. So if on this ground you are critiquing Indian judiciary, then you are barking at the wrong tree. You should have criticized the parliament for enacting such a law because it is the parliamentary law which makes pre-suit mediation mandatory. And what if, look at it this way, the courts ignore this pre-suit mediation and ask the parties to directly file complaints and suits before the court, then you will claim judicial overreach, judicial adventurism. You will say the court is deliberately not following the law of the land, because when the law of the land makes pre-suit mediation mandatory, why is court not insisting on this? So you're barking on the wrong tree. Number one. Number two, Sanjeev Sanyal, without explaining what it means, he said that in India there is 99 to 1 problem. And what is this 99 to 1 problem which I have understood? I'll give you a simple explanation to that. The world changed. When? After 9/11. 9/11, 4 planes were hijacked, 2 hit the World Trade Centers, 1 hit one side of the Pentagon, which is the defense establishment of United States, and the one plane which was about to cruise towards the White House, the official residence of the President of the United States, it was shot down near Pennsylvania. And some argued that it was also because the the hostages, the passengers of that plane, they pulled this plane down because they didn't want massive destruction if this plane hits the White House. Be that as it may, after that, as I said, the world changed. World changed in a sense, more security checks at the airports. So who is bearing the cost? 99% of the people, because one person decided to hijack the plane. And because that one person violated the law, now 99 will have to suffer. Sanjeev Sanyal argues that for that we don't need a law. The courts should have taken onto themselves and resolved such cases where 1% people are violating, committing crimes. We don't need these lengthy laws, rules, regulations, so many disclosures, so many things to follow because we have been following, we have been making these laws, making such rules just to keep in mind that 1% of the people of this country may violate them. You might have seen if you're traveling in a plane and if the pilot wants to come out and use the restroom, there are air hostesses which block the pathway, which block the aisle so that you don't cross and enter the cockpit and then hijack the plane. The doors of the cockpit were then refitted. Different material was used to make it rock solid so that it is not opened. You will always see that one air hostess will enter the cockpit to ensure that a pilot is not manipulating the system. So lots and checks and balances. You are wearing a shoe which has some element of metal. You have to take it off, put it in the tray, and then take it through the X-ray machine and then collect it again. It's making life difficult for the commuters. But it is because one person decided to hijack. Now 99% are suffering. Mr. Sanjeev Sanyal says this is the 99 to 1 problem. India's rules and regulations are drafted to guard against the abuse of laws by a small fraction of the people. Even if there are such small fraction of the people, it's the job of the judiciary to expose them and resolve those exceptions. But Mr. Surit Parthasarthi argues that Mr. Sanjeev Sanyal is barking at the wrong tree because the fault lies somewhere else. Indian judiciary may not be perfect, but to use Indian judiciary as a tool and then put all the blame on the Indian judiciary is wrong. Don't make Indian judiciary a scapegoat where the fault lies somewhere else. And where is the fault? According to Surit Parthasarthi, these are very important points for your mains. Tax authorities file appeals against routine orders as a matter of course. You have filed tax, income tax return. Now there is an income tax notice to which you respond, right? The matter goes to a tribunal and the tribunal rules in your favor. What will the tax authority do? They file an appeal. Despite the fact that they know that they are wrong and the petitioner is right, they still file an appeal as a matter of course because they say the logical conclusion is let this matter be dragged and then the matter goes all the way to the Supreme Court of India. So whose fault is it if the matters reach the courts? It's the job of the government departments. Ministries are fighting over simple contractual matters that they ought to have honored. For example, there is a road which was to be developed, constructed, laid, and the contractor has done all the hard work and done it spectacularly well. But the maintenance of this road may not have been the responsibility of this contractor. I'm just giving an example. And then there is a dispute. It all depends upon the contract that you have. If the road constructing agency does not have the mandate to maintain this road after 10 years, and if this road develops some potholes, then the ministry drags this contractor to the court, despite the fact that knowing that this contractor is not at fault. Public sector enterprises are PSUs, they are filing cases, squandering judicial resources, and they know only one thing: file a case. File a case and then file an appeal and then file an appeal, then go all the way to the Supreme Court. So the problem is with the executive. you would also know that the biggest litigant in this country is the union government. We have discussed in our previous sessions how there is now a need which has been accepted by the government, that we want to reduce government litigation, because government departments, they are filing cases against each other which they should have resolved themselves. Why go to the court? Why can't you resolve disputes among yourself? I, as a citizen, I have been denied, for example, my pension. For that, I have to go to the court. What sort of a country are we living in? For my rightful claim, why do I need to court? Why do I need to go to the court? Why can't the government department accept that I am entitled to this pension? When there are teachers, public service employees, doctors, when they are forced to litigate for simple benefits that they are entitled to, the fault is with the executive. The fault is with the governments, not with the judiciary, because judiciary cannot not entertain these cases when they are filed before them. Another criticism that is leveled against the judiciary is that they have a beautiful 9 to 5 kind of a job. They start at 10:30 a.m. and by 4 p.m. they are done. Look at the beautiful job that they have. They have a perfect work life balance, so they don't work well. They don't work hard enough. That's the criticism of the judiciary. But people fail to realize that visible things are between 10:30 to 4 p.m. I'll give you a simple example. If, for example, my company has to pay me money for the work I'm doing for them, will they pay me money for only the number of hours of classes that I take? Someone will say, why are these teachers paid a lot? They just take 1 hour class on a daily basis, maximum 3 hours class a day. For 3 hour class, they are paid this much. Oh my God, they have a perfect work life balance. But to prepare for that 3 hour class, we may have to prepare for 12 hours on a daily basis as well. So you might think that these judges are only working from 10:30 to 4 p.m. But 10:30 to 4 p.m. they're only hearing. When do they get the time to write judgments, to brainstorm? So the visible part is 10:30 to 4 p.m. But the judges may hear anywhere between 50 to 100 cases during this window. It is a very difficult job. So don't criticize the judiciary for their work timings or for the vacations that they take. It was argued, and it was long considered, that Indian judiciary is notorious for the number of vacations that they take. Summer vacation, approximately 7 weeks, typically between May and July. Then a Dasera break for a week. Then Diwali break again for a week. Then Christmas and New Year break around 2 weeks at the end of December. It is argued that Supreme Court sits only for 194 days in a year. So if you look at Indian judiciary from outside, they are sitting only for 194 days in a year. That too 10:30 to 4. Oh my God, what a beautiful work life balance do they have. But we need to understand that these judges who hear 50 to 100 cases in this window of 10:30 to 4 p.m., when will they get the time to write judgments? To brainstorm on what sort of judgments do we need to write? When do they get the time to read the judgments given by other judges? Judgments given by previous judges, judgments given by judges of different countries, so that we can incorporate that jurisprudence in India. And in fact, even during vacations, there are vacation benches of the court. Important cases such as the NEET retest case was heard by the Supreme Court, but it's vacation bench. So judiciary never sleeps. Judiciary has its flaws, but this article is there. Look at the title of this article, calling out the criticism of the Indian judiciary. We are here to defend Indian judiciary. It may not be perfect, but don't make it a scapegoat. Something else. Mr. Surat Parthasarthi writes that what Mr. Sanjeev Sanyal is critiquing Indian judiciary for, it's not the fault of the judiciary. Yes, there is a pendency of cases, close to a lakh case pending in the Supreme Court. Cumulatively, district court, high courts, and the Supreme Court, we have more than 4.5 crores cases pending. Now, touching this number is touching 5 crores. Yes, as immortalized by Sunny Deol, Tariq pe Tariq pe Tariq. But that's not, there is a burden on judiciary, but that's not because of the judiciary itself. The judges to population ratio should be 50 to 1 million population. And we have 10.5 judges per million population in India. Whose job is to appoint judges? The government. Why are they not appointing? Plus, the laws are misconceived, vague, and designed for optics rather than clarity. Now, Suhrit Parthasarthi's words, not my words, don't lynch me for this. He says you have converted Indian Penal Code, Criminal Procedure Code, Indian Evidence Act, and given it Hindi names of various sanhitas. Bharatiya Nyay Sanhita, Bharatiya Nagarik Suraksha Sanhita, Nyayik Adhiniyam, so on and so forth. Just by giving Hindi names to English laws, you're not changing anything substantial. But at the same time, look at the complexity. Complexity in the sense the new income tax law will enter into force from the next year. And there, what the parliament has done, parliament has replaced this word notwithstanding with a word irrespective. Now, there is something called judicial precedent. What is the meaning of this term notwithstanding, which is mentioned in various laws, mentioned in the constitution as well? For example, notwithstanding, mention anywhere in any other statute or constitution, this provision will prevail. So there is a long legal precedent, there is a long jurisprudence of what is the meaning of this word notwithstanding. Now, for the sake of simplicity or to just optics, to tell the world that we are changing the laws, you have changed this term notwithstanding in income tax laws with irrespective, rendering the entire jurisprudence where we have thousands of cases of precedent where we have explained what is the meaning of this term, implication of this term notwithstanding, you have rendered them to nullity. You thought, according to Mr. Surat Parthasarthi, that you will replace income tax laws with a simplified version of the tax law. But instead, what you have done, you have created further problems. Now, to get the interpretation of what is the meaning of this term irrespective, you still will have to go to the court. And the court now will have to come out with another set of legal precedent, another set of jurisprudence to explain what is this irrespective. So you are complicating matters rather than solving them, and complicating them for judiciary. And then you will blame the judiciary that judiciary is not doing its job. The judiciary is not flawless, but if we are serious about reform, we must look beyond distortions on vacations and delays and confront the structural failings that lie elsewhere. Elsewhere, in the sense, make the laws less vague, explicitly clear. The language has to be clear, particularly of the criminal laws. And we are today governed more by delegated legislation rather than laws. And it is this menace of delegated legislation which Lord Havert, what did he call it? New despotism. Judiciary is not flawless, but don't make it a scapegoat for anything and everything that is wrong with our nation. That's this article. Clear? Any questions? Okay. Refugees Infiltrators. Union Home Minister Mr. Amit Shah has now said, and rightly so according to this editorial, that we need to make a distinction between who is a refugee and who is an infiltrator. But this editorial says for that we need a strong, clear, coherent refugee law, which does not exist. India is not a signatory to United Nations Convention on the status of refugees, which was signed and adopted in 1951. Nor are we signatory to the additional protocol of 1967. Why? It is argued that the Indian state was against this convention. Why? Because it was Eurocentric. Why Eurocentric? Because this convention only spoke of those refugees who have been made refugee at this particular time, before this particular time, 1st of January. And it only talks about refugees who have been rendered homeless in Europe, European refugees. Why? Because Europe was the center of the Second World War. Long story short, why should India sign and ratify United Nations Convention on the Status of Refugee when this particular convention talks about a time limit and geographical limit? Time limit, it only talks about refugees prior to and during Second World War. It only talks about refugees who are rendered homeless in Europe. So it is specific to Europe, specific to a time period. We don't want to sign it. But then the additional protocol of 1967 removed this time limit as well, spatial limit as well. Now it talks about refugees anywhere in the world without this time limit. Even this we have not signed. Why? Because even without this ratification, we have given refuge to thousands of people, whether it is from Sri Lanka, whether it is from Tibet, whether it is from various other countries of the world, including the Afghan refugees. But who are these refugees and who are these infiltrators? We need to make a distinction between them. Because in absence of a law, then this definition can be, this approach can be arbitrary. Because if there is no law and the union government will, on its own terms and conditions, based on its own whims and the fancies, will designate someone as a refugee and someone as an infiltrator, it will be an arbitrary decision and it will violate fundamental rights under Article 14. And remember, Article 14 is applicable on anyone who is residing within the territory of India. It does not only apply to citizens. And this article talks about, this editorial talks about, we need a law, a refugee law, which is non discriminatory. Because what this column talks about is that we have a law called Citizenship Amendment Act of 2019, which spoke of that if you are Hindus, Christians, Buddhists, Jains, Sikhs, Parsis, and if you belong to three Islamic countries such as Pakistan, Afghanistan, and Bangladesh, and if you have entered on or before December 31, 2014, we will grant you citizenship. But the fact of the matter is that since it discriminates on the grounds of religion, rendering the Rohingya Muslims ineligible to be granted citizenship, despite the fact that they may be facing religious persecution in Myanmar. So we need a law which can be non discriminatory, which can clearly make out a distinction between refugees and infiltrators. But this editorial agrees that there is no issue with if the government, what this government does, gives humanitarian relief to only few sections of the people and ignores others. Even that's okay. But even that law has to be compassionate, has to be non discriminatory. Otherwise, it will fall foul of Article 14 of the Constitution. There is a question on your screen. Let me know in the comment section what is the right answer. The Immigration and Foreigners Act 2025 repeal which of the following acts? The Immigration and Foreigners Act 2025 repeal which of the following acts? Passport Entry into India Act 1920, Registration of Foreigners Act 1939, the Foreigners Act 1946, the Immigration Carriers Liability Act 2000, the Passports Act 1967. This has not been repealed by this law. So A 1234 is the right answer. Someone asking what is the principle of non refoulement? I'll give you a simple explanation of this. For example, there is a country A, and in this country, there are people belonging to X, Y, Z community, whether ethnic, linguistic, religious, whatever. These communities have been persecuted. Their life is in danger in this country A. And these communities now decide to move to country B and seek refuge in country B. What if this country B may not be able to provide benefits to them because they are already overpopulated, they have less resources, so on and so forth, which means B needs to deport XYZ. Deport where? You cannot deport them back to A because in A their life is in danger. That is principle of non-refoulement. That means those communities whose life is in danger in A, and if they migrate from A and move to a country B, if B is a signatory to United Nations Convention on the Status of Refugee 1951 or its additional protocol of 1967, B cannot deport these people back to A because in A their life is in danger. That's principle of non-refoulement. Let's look at another interesting article written by Mr. Sanjay Hegde in the Hindu newspaper, a reading of a revisionism in constitutional history. There is Sir Benegal Narsingh Rao, Sir Bian Rao, and then there is Dr. B.R. Ambedkar. We all know that Dr. B.R. Ambedkar is considered to be the father of Indian Constitution, the author of Indian Constitution. Some people say it is Ambedkar's Constitution, right? Now, there is a campaign launched by some sections of our society who say that history needs to be corrected. It is not Ambedkar's constitution. It is Sir B.N. Rao's constitution. Who was Sir B.N. Rao? He was an Indian civil servant. He was a jurist. He was once the Prime Minister of Jammu and Kashmir when it was a princely state. He was then a judge of the International Court of Justice. He was the one who was responsible for the drafting of the Constitution of Burma. But most importantly, he was the constitutional advisor to the Constituent Assembly, which drafted India's constitution. So these people say the credit should be given to B.N.R. Rao for writing the constitution, not B.R. Ambedkar. Why? Because when Mr. Sir B.N. Rao was appointed as the constitutional advisor to the Constituent Assembly in July 1946, what was his assignment? His assignment was technical and preparatory. He was the one who was responsible for drafting the Government of India Act 1935. And what he did, Sir B.N.R. Rao, he examined different constitutions of the world: American, Canadian, Irish, Weimar Constitution, consulted various constitutional scholars such as Harold Lasky and various other experts. And finally, he came up with a draft. This draft was of 243 articles, and there were 13 schedules in in that draft. And it is this draft which was prepared by Sir B.N. Banigal Narsingh Rao, which was presented to the Constituent Assembly. And then this Constituent Assembly had to decide whether we need to implement this, brainstorm it, fine tune it, amend it, add it, alter it. And then Constituent Assembly did its job. So if the real draft was prepared by Sir B.N. Rao, why is the credit given to Dr. Ambedkar? This article says that his authority was scholarly, not representative. Dr. Ambedkar was the representative of the people. Sir Benegal Narsingh Rao was there in the Constituent Assembly as a constitutional advisor, but he had no representation of the people. And Mr. Sanjay Hegde says, you may think that this is an academic discourse, that who should be given credit for drafting our constitution, Sir B.N. Rao or Dr. Ambedkar? No, but it is not scholarly or academic discussion. It is a matter of caste. By ignoring Dr. Ambedkar's contribution, you're ignoring a Dalit's contribution to India's constitution. And you want to erase the constitutional memory, the history of the constitution. And you want to say that a Brahmin was responsible for drafting the constitution. So the radical text, which is Indian constitution is not a political document. It's a social document. It's an emotional document. It is a moral document. And it has a radical text to it. When it says Article 17, untouchability is abolished and its practice in any form is forbidden, it is radical in its approach. And that is why Gautam Bhatia wrote a beautiful book, Transformative Nature of Indian Constitution. So this debate, this argument may sound academic, but it is not, according to Mr. Sanjay Hegde. It represents an attempt to diminish Dalit agency in India's founding story and erase the moral force that Dr. Ambedkar brought to making of India's republic. If Sir Benegal Narsingh Rao, his job was to act as the constitutional advisor to the Constituent Assembly, his task was to prepare a draft of the constitution. So his contribution is important, has to be recognized, but it was only technical, scholarly. Dr. Ambedkar's role was different. Dr. Ambedkar was the chairman of the drafting committee of the constitution. He had to turn that legal draft which Sir Benegal Narsingh Rao created and turn this document into a political document. Imagine these were not easy circumstances. There was a partition of this country along religious lines. There was the assassination of the Mahatma. Mahatma Gandhi was assassinated. That is why these provisions had to be debated, discussed clause by clause in the Constituent Assembly. So, Dr. B.R. Ambedkar's job was to persuade other members of the Constituent Assembly that we need this constitution. He had to build consensus amongst those who were sharply divided whether we should have a secular India or a Hindu Rashtra, whether we need to focus more on fundamental rights or fundamental duties, because fundamental duties did not exist in the original draft. So, if the text was provided by Sir Benegal Narsingh Rao, it is Dr. Ambedkar who made it a living instrument of justice. So, the job of Dr. Ambedkar was monumental. And that's what Dr. Ambedkar said in the Constituent Assembly. He said the credit that is given to me does not really belong to me. It belongs partly to Sir B.N. Rao, the constitutional advisor to the Constituent Assembly, who prepared a rough draft. Rough draft. And then this rough draft was considered by the drafting committee, whose chairman was Dr. Ambedkar. And Dr. Ambedkar did not take full credit to himself. He credited B.N. Rao. He credited Mr. S.N. Mukherjee, who was the chief draftsman of the constitution. Not just this. The campaign to elevate B.N. Rao and sideline Dr. Ambedkar is not driven by scholarship alone. It talks about this discomfort that a Dalit thinker could stand at the center of Republic India's founding movement, because Dalits were tortured, victimized, and persecuted after the later Vedic period. Dr. Ambedkar himself, when he was studying in a school, he had to s- sit on a sack, and then he had to take that sack back to his home. Otherwise, it will cause pollution to the members of the other castes. If water was to be given to Dr. Ambedkar, it could be given by a peon. And if someone else has to give water to Dr. Ambedkar, this water was made to fall from a height. Otherwise, it will pollute the members of the other castes. And if that individual who performed spectacularly well in his studies got the doctorate degree from the world's top class universities, is India's foremost thinker. If such an individual from a Dalit community is at the heart of founding India's republic, it is causing discomfort to some people who don't want a Dalit to be associated with this beautiful movement. And if you want to sideline Dr. Ambedkar and you want to give all credit to Sir Benegal Narsingh Rao, what you're trying to do, you're trying to turn that this constitution's making, it was just a bureaucratic exercise. But no, it was not a bureaucratic exercise. It was a revolution in making. As I told you, constitution is not just a legal document, it is a social manifesto. This constitution was born of a conflict of a partition. Even with the death of the Mahatma, there was a hope that now the country will stay together. And then we redeemed ourselves. It is this constitution which represented the arrival of the oppressed at the table of power. If you detach Ambedkar, you're detaching and robbing the soul of the constitution. So, this is not a campaign to just prove who wrote the constitution. This is a campaign to snatch and rob the soul of India's constitution. And you will be surprised to know that Dr. Ambedkar may not have been in the Constituent Assembly at all. He was elected from a constituency in Bengal, but then that seat went to Pakistan after partition. So he was left without any seat. Congress, you would know, was against Dr. Ambedkar. Dr. Ambedkar was also not interested in the ideology of the Congress party. But Mahatma Gandhi prevailed, got the Congress to support his candidature so that he can get elected from Bombay to the Constituent Assembly. Congress supported him, and Dr. Ambedkar became the member of the Constituent Assembly from Bombay. So his participation in the Constituent Assembly was itself the result of a decisive act of political wisdom of Mr. Gandhi. And then he played that spectacular role. Mr. Sanjay Hegde, who is the author of this article, he says every republic must guard its memory. To give credit where it is due, you can't say Sir Benegal Narsingh Rao played no role in the constitution's making. But to elevate Rao above Dr. Ambedkar is to drain the constitution of its radical spirit, is to tell that creating and crafting and drafting this constitution was a mere bureaucratic exercise. A technical competence is required, which Sir Benegal Narsingh Rao had. But if you say that this constitution is leading to social transformation in India, for that you can't absolve the role of Dr. Ambedkar. It needed a scholar's precision, but it also needed a reformer's conviction, and that reformer was Dr. Ambedkar. When the constitution was adopted, many political leaders spoke in the Constituent Assembly and credited Dr. Ambedkar. Nehru did, Patel did, publicly acknowledged the role of Dr. Ambedkar. No one suggested that Dr. Ambedkar is not the Constitution's principal author. Because even these great leaders, the Nehrus, the Patels, they realize that there is a difference between drafting a text, which Sir Benegal Narsingh Rao did, and shaping the nation's conscience, which Dr. Ambedkar did. Rao built the structure, Ambedkar filled it with justice. Sir B.N. Rao deserves gratitude as a constitutional engineer. Dr. Ambedkar remains the architect, the moral founder of the modern India. To deny that truth is to deny the republic, says Mr. Sanjay Hegde. This is another topic of our discussion. Okay? Supreme Court to hear contempt plea over lawyer's attack on CGI bench. The former Chief Justice of India, Justice Gawai, was hit by an advocate inside the Supreme Court room, which did not hit the Chief Justice. But it is argued that an attempt to throw a shoe at CGI was because of some of the comments that CGI made regarding Lord Vishnu. But others say if Justice Gawai was not a Dalit, no one would have the audacity to throw shoe at the Chief Justice of India. Maybe again, a Dalit becoming the Chief Justice of India may not be acceptable to some members. A community which was disempowered politically, socially, educationally, now through their determination and competence and talent, if they're occupying important constitutional positions that may not be acceptable to some. But be that as it may, you need to understand this question on your screen. Which of the following is not a valid defense against a charge of criminal contempt under the Contempt of Courts Act 1971? Let me know in the comments what is the right answer. Slightly difficult question, but you should be able to answer. You have freedom of speech and expression under Article 19, 1A of the Constitution, but it is not absolute. There are reasonable restrictions. And there are 8 reasonable restrictions imposed under Article 19, Clause 2 of the Constitution. One of them is contempt of court. Contempt of court can be civil as well as criminal. For example, I gave an undertaking before the court and I told the court that I will be present before you on the 26th of January 2026. But I did not appear. What am I doing? I'm willfully, deliberately disobeying and violating an undertaking that I gave to the court. This is a civil contempt. I'll be prosecuted. I'll have to give damages. But criminal contempt is something dangerous. If you tend to scandalize the judges, the judgments given by the court, if you obstruct in the nature of justice, Throwing a shoe at the Chief Justice is obstructing justice, scandalizing the judiciary. As such, it is contempt and criminal contempt. And for that, there is a way you can approach the court. How? One, either the court will so motu on its own take action. For example, an article has been written in a newspaper. For example, I say something in this discussion which amounts to contempt of court, and there is a judge who is also listening to my lecture. Tomorrow he goes to the Supreme Court, he takes the matter on its own without somebody approaching him. He says it's a matter on our own. We have decided to watch a lecture given by this polity educator. He has committed contempt of court. Now defend yourself. Or Attorney General for India or the Solicitor General of India may approach the court. Sir, we watched a video lecture yesterday on Unacademy IAS English channel, and there was this individual who was committing contempt of court. Please take action against this individual. So, who can approach the Supreme Court? Either the court will act on its own, or the Attorney General for India or the Solicitor General for India will approach, or a third person. Now, who is this third person? If not the Supreme Court itself, if not the Attorney General or Solicitor General, third person may be you. You will approach the Supreme Court. Please take action against this polity teacher for committing contempt of court. But you cannot approach the court without getting written consent from approval, permission from the Attorney General or the Solicitor General. This provision is there to save the time of the court. Otherwise, frivolous, vexatious petitions of contempt of court will be filed before the court. It will drown Supreme Court in these cases. Ultimately, the pendency of the cases will rise. That is why if you want to file a contempt of court case against me, you have to take the permission of the Attorney General so that Attorney General can see what complaint you have, whether it is contempt or not. Because not everything that you say against judiciary is contempt. Which of the following is not a valid defense against the charge of criminal contempt? There are some which is valid defense. Even if you say this, you will not be booked for contempt. For example, truth. If you are criticizing Supreme Court, but it is based on truth, but truth alone will not help you. This truth you are saying for public good. Only then it is your defense. If you are fairly and accurately reporting the judicial proceedings which have been happening, it is not contempt. Which means, can you publish that a shoe was thrown at the Chief Justice? Can this be viewed as contempt of court? Now, this newspaper is throwing shoe at the Chief Justice? No, this is an accurate, fair report of what happened in the judiciary. Fair and reasonable criticism of the judicial decision. For example, in November, this month, so many decisions were taken by the court, which I may not agree with. I will criticize the court. For example, a presidential reference. For example, the environmental case. So many cases I may not agree with. Is that contempt of court? No. If it is fair and reasonable criticism of judicial decisions, it is not contempt. But truth alone is not a valid defense. Sir, how is then A and D different? Listen to me carefully. There is a case pending in the court, and there is a judge who is gay. And I write or give a speech or make a video that a gay judge of the Supreme Court is hearing a case whether same sex marriages are legal or not. Is this contempt of court? Prima facie, no. Why? Because I'm saying truth. Yes, this guy is gay. This judge is a gay. But the court can still punish me for contempt because you're trying to scandalize judiciary. What is the public good that you're serving by revealing that this judge is a gay? What is it going to change on ground? You are trying to cast aspersions in the minds of the people through which they will not agree with the judgments given by the court, because you are trying to scandalize the judiciary. You are saying truth, but you are not saying this for larger public good. You are saying this for scandalizing the judiciary. You are guilty of contempt. So truth alone is not your defense. Truth which should be told for larger public good. That's where you can be saved from contempt. Okay? Great. Let's look at another article on CBI takeovers, a judicial standpoint. Superstar Vijay. Now, you can agree or disagree with me whether he's a superstar or not, but a film actor who has made his mark in the Tamil film industry. He is now a politician, set up a political party, and organized a mega rally at Karur district in Tamil Nadu. And then there was a stampede in which 30, 40 odd people died. Was the stampede deliberately orchestrated by the ruling party in Tamil Nadu to ensure that public sentiment in favor of Mr. Vijay gets sidelined and he will be then accused of putting people's life in danger? Or was it deliberate act by Mr. Vijay that he came late to that rally because he wanted the momentum to be built? He wanted more and more people to join. Was it dereliction on part of the police where they did not anticipate this much crowd and they were not ready for crowd management? Who was responsible for the stampede? We need to know. The nation wants to know this. And for that, Madras High Court appointed a special investigation team investigate this Karor stampede. Instantly, without losing time, the Tamil Nadu government, led by Mr. Stalin, constituted an inquiry commission headed by Justice retired Oruna Jagadisan. Find out what happened at Karur, what led to the stampede, who should be held responsible. Some of the victims and their family members, they approached the Supreme Court. My lord, we don't trust the police. They may not conduct a fair inquiry. And that is why we're urging you that please transfer this case to the Central Bureau of Investigation. CBI, you would know, is governed by Special Police Establishment, which was formed in 1941, or the Delhi Special Police Establishment Act of 1946. CBI was primarily set up to investigate corruption during the Second World War, and then this jurisdiction of CBI was extended to railways as well. Long story short, you would know that there is an entity called CBI, which is a premier investigation agency. Its original mandate was to investigate the corruption in the war procurements during the Second World War. Then it was extended to railways, then extended to central government employees, employees of the union territories. Can CBI investigate state government employees in a particular state? For that, that state has to give general consent or a specific consent. General consent is there is a central government employee working in West Bengal. You don't need West Bengal government's permission. You can come and investigate him. Specific consent is that one particular event has happened, maybe murder. For example, the murder of Arushi Talwar and Hemraj in Noida, way back, I think, in 2010. For that, for specific case, we can hand over this case to CBI. That means CBI in our state will investigate only this case, nothing else. But since CBI is under the jurisdiction of the central government, famously or infamously, Supreme Court referred to CBI as a caged parrot. And what is this caged parrot? CBI was investigating coal scam when UPA was in power. UPA 2. Dr. Manmohan Singh was the prime minister. And CBI had to file a charge sheet before the court. Before filing charge sheet before the court, the CBI director is meeting the law minister. I think Mr. Ashwini Kumar was the law minister. When you are investigating the central government for the coal scam, allocation of coal, and you are seeking inputs of the law minister. This amounts to interference in CBI by the executive, which should not happen. CBI should be an independent investigation agency. Supreme Court said this is classic example of caged parrot. CBI is now a caged parrot. It is parroting the words and thoughts of the central government. And then when Mr. Modi came to power in 2014, allegation is that CBI was used against opposition leaders, targeting the opposition ruled governments and states. And this is where this general consent was withdrawn by various states: Telangana, Tamil Nadu, West Bengal, Rajasthan, Chhattisgarh, so on and so forth. Mizoram was the first state which revoked the general consent to the CBI. Long story short, even if there is a state such as Tamil Nadu, which has withdrawn general consent to CBI, can CBI investigate in Tamil Nadu? Yes, on the orders of the court. And this time the court ordered that this Karur stampede should be handed over to CBI. Why? Supreme Court has to give its reason why we are transferring this case to the CBI. Supreme Court said there are two sweeping factors. One, the political undertones of the case. As I told you, it was a political rally, the first big political rally of actor come politician Vijay. Was it a sabotage by the ruling party or other political parties to ensure that people hate Vijay? That we need to understand. Second, there was a perception that the DGP of Tamil Nadu is saying that my police is not involved. My police has done spectacular duty. They are not involved in this. They should not be held accountable for this. Petitioners approached before the court and said, Sir, if the Tamil Nadu police will investigate, the Tamil Nadu DGP is saying that my police is not involved. How can they conduct fair investigation? That is why please transfer this case to the CBI. Supreme Court said because of these two reasons, the conduct of the police may create an impression in the minds of the citizenry about the impartiality of the investigation, the fairness of the investigation. That is why it is necessary that this case be transferred to the CBI. But on this, look at the question on your screen. The jurisdiction of the CBI within states often hinges on consent under the DSPE Act, the Delhi Special Police Establishment Act of 1946. However, constitutional courts have directed CBI probes without such consent in exceptional cases. Explain the legal justification, the limits and safeguards of this power. KV Rajendran V, Superintendent of Police, CBCID 2013. Supreme Court itself is saying that transferring a case to the CBI has to be a measure of the last resort. When can the courts transfer a case to the CBI? When there is a material placed before the court which necessitates that this case be shifted to the CBI. Produce material before the court. Produce documents before the court. What sort of documents? That high ranking state officials are involved, influential persons are involved, the local police is acting in such a manner that doubts can be raised in the minds of the ordinary citizens that this investigation may not be impartial. Produce material, produce some sort of evidence, and on the basis of that evidence, the courts can transfer the case to the CBI. But the courts cannot transfer the cases on mere allegations. Allegations can be leveled against anybody, but you have to substantiate your allegations with some material which can prove these allegations. But this order of the Supreme Court to order CBI investigation in Karur stampede, it was a 25-page order, And the Supreme Court said we are shifting this case to CBI only on the basis of the allegations raised by petitioners. There was no material provided before the court on the basis of which the court may have been told that there are influential people involved, that the conduct of the police may be partial, that the high ranking state officials are involved. It is easy to say that the DGP is involved. Show some material evidence that DGP is involved. On mere allegations, we cannot shift the case to the CBI. Another important case, 2019, Shri Shri Ram Janki Asthan Tapovan Mandir. Supreme Court said it is not for the judiciary to make sweeping remarks against the state government and subject a particular case to CBI investigation. Just because you have alleged something, just because there are allegations against the state. But that's exactly what Supreme Court did by transferring this case to CBI in the Karur case. On mere allegations, the case was shifted to the CBI, which violates the federal compact. And let's not forget, federalism is part of the basic structure. Using CBI, a central agency in a state which has revoked general consent, it will demoralize the state police, because state police, unless and until you can prove that they are complicit in this crime, only then you could have transferred this case to the CBI. Otherwise, state police should have been allowed to handle this investigation. Done? Okay. Now let's look at another column in the Indian Express written by former chairman of the National Commission of Minorities, Mr. Tahir Mahmood. A commission of omissions. Currently, National Commission for Minorities, it has no chairman or members. And you can say that this National Commission for Minorities is defunct. Maybe it will be dead soon. Delhi High Court was hearing a public interest litigation. This PIL was asking that Delhi High Court please direct the government, issue mandamus so that this National Commission for Minorities chairperson and members are appointed. This National Commission for Minorities, if we look at its origin, it was set up in 1978 under the resolution of the Ministry of Home Affairs. So it was non statutory, extra constitutional body. But then in 1992, this National Commission for Minorities was given a statutory status. That means now it was enacted by a law. And this National Commission for Minorities had all the powers of the civil court. Civil court, what can court do? Court can ask the government to produce before it documents, which the government cannot refuse. Court can ask you to be present before me, which you cannot refuse, otherwise you will be guilty of contempt. Similarly, National Commission for Minorities was given the power of a civil court. That means it can produce documents, it can ask people, it can requisition documents, it can ask people to be presented before them as witnesses. That was the power of the National Commission for Minorities. But 1992, it was given statutory status, and 1992, another body was set up. Look at the link, known as National Human Rights Commission, which was based on, you would know, Paris principles. This NHRC is also a statutory body. It's not a constitutional body. Enacted under the Protection of the Human Rights Act. But why was this National Human Rights Commission set up? Because the government said that there is a false and motivated propaganda against the government by foreign powers, by so called Indian civil society organizations, even Indian civil rights organizations, that there is increasing violation of human rights happening in the country. And when this NHRC was created, the chairpersons of the pre existing national commissions, such as National Commission for Minorities, SCs, STs, and Women, they were made ex officio members of the NHRC. Long story short, NHRC is without a chairman and the members. There was a public interest litigation filed in the Delhi High Court. Delhi High Court was asked, please issue a mandamus to the union government so that union government can appoint the chairman and members of the National Commission for Minorities, because right now it is non-existing, it is defunct. To understand that, we need to understand that first it was a non-statutory extra constitutional body set up in 1978 under the resolution of the Home Ministry. Then in 1992, it was given a statutory status. In the same 1992, another body, NHRC, was constituted, created a statutory body. Why? Because the government thought that there is a false, motivated propaganda by the foreign powers and Indian civil society organizations that there are growing human rights violations in India. And when this NHRC was set up, NHRC will have the chairman, it will have some members as well, and some members will be ex officio. That means those who are the chairman of National Commission for Minorities, National Commission for Scheduled Castes, National Commission for Scheduled Tribes, National Commission for Women, automatically they will also be members of the National Human Rights Commission. But Mr. Tahir Mahmood says none of these so called national commissions have ever enjoyed autonomy. On paper, they are autonomous, but they have never enjoyed autonomy. And these commissions have not brought any revolution to the lives of those for whom they were created. Has NHRC led to the improvement in the lives of those people whose rights have been violated? No, according to him. Former Chief Justice of India, Mr. H.L. Datu, he called NHRC a toothless tiger. Why? Because no matter what recommendations are given by NHRC, they are not binding on the government. There is no mechanism under NHRC through which you can enforce your directions. No. So none of these national commissions have led to or brought any revolution in the lives of those for whom they were meant to be created. At least the National Commission for Minorities, says Mr. Tahir Mahmood, with its huge annual budget, is easily avoidable. Why should taxpayers fund a body which is ineffective? Its history of 47 years shows us that whatever little minorities have in this country, none of it is because of National Commission for Minorities. So if it is thrown into the dustbin of history, it will be worthless to shed tears on its unceremonious exit from the national scene. You can write this in your answers, in your mains answers. Former chairman of National Commission for Minorities, Tahir Mahmood, saying that if it is thrown into the dustbin of history, it will be worthless to shed tears on its unceremonious exit from the national scene because it has done nothing. Let's look at the practice question on your screen. Consider the following statements regarding the National Commission for Minorities. National Commission for Minorities is a constitutional body established under Article 338 capital B of the Constitution. No, it is not a constitutional body, it is a statutory body. While inquiring into complaints, the NCM has powers of a civil court, such as summoning witnesses and requisitioning documents. Correct? The chairperson and members of the NCM hold office for a term of 5 years. They hold office for a term of 3 years. For the purposes of the National Commission for Minorities Act, minority means communities notified as such by the central government. Correct? 2 and 4 is the right answer. Which are these communities? Muslims, Christians, Sikhs, Jains, Buddhists, Parsis. These are the six nationally determined minorities. Although there is a campaign that minorities should be decided state-wise. For example, Hindus can be a minority in Punjab and Jammu and Kashmir. Hindus can be a minority in Nagaland. Sikhs may not be minorities in Punjab, so on and so forth. So that's the campaign. That matter is before the court. We will have to wait and watch. These were the 10 important topics which appeared in various newspapers such as the Hindu, the Indian Express, the Hindustan Times, relevant for your prelims and mains from the world of Indian polity in in October 2025. November session we will have next month, early next month. And if this session has been of some help for you, please let me know in the comment section. Do not forget to press the like button and subscribe, and you must. Okay? I'll see you again next time. Till then, have a great time. All the best. Bye bye. Good night. If there are any questions, please let me know. I'll be happy to resolve. Any questions, anyone? Please start mains. Mains oriented sessions are ongoing on the app. You can visit. Okay. Thank you. All the best. Good night.